Hi everyone, my name's Shazia Khan, and today we'll be looking at Learning Outcome 2 on the Unit 3.27, which is the English legal system, and the Learning Outcome 2 is to understand the rules of statutory interpretation. I just want to give you an overview of the last session and what we looked at in regards to Learning Outcome 1. We looked at, in Learning Outcome 1, we looked at understanding the key principles of English law. We then went on to look at the different methods by which laws are made in regards to where a bill is passed and becomes a law. We looked at the different stages in English law in regards to the passing of a bill and where it becomes law, such as first reading, second reading, committee stage, report stage, and third reading in the House of Commons and in the House of Lords, and the difference between each one in regards. And then we looked at the issue of royal assent. We then went on to look at the difference between criminal and civil law, and looked at the different considerations made by the civil courts in regards to the laws, and also mentioned examples of civil and criminal law, and looked at the elements in regard to any sort of sanctions and remedies in both criminal and civil law. We also looked at how a case is processed in criminal and civil cases, and the considerations that courts take into account in both civil and criminal cases. We then went on to look at the difference between public law and private law, and what the difference is between them in regards to how each one operates differently to the other. We looked at the similarities between each one, and we also looked at the remedies under public and private law. Now we're going to look at going into Learning Outcome 2, which is to look at the issues around understanding the rules around statutory interpretation. So the learning outcomes for today's session is to explain the traditional techniques of statutory interpretation and how they are used, and also to look at intrinsic and extrinsic aids. So 2.1, we're going to look at explaining the traditional techniques of statutory interpretation and how they are used. So firstly, we'd like to introduce what statutory interpretation is, so the introduction. The aim of statutory interpretation is to arrive at the legal meaning of the legislation, or in other words, the meaning that conveys the legislative intent. So the primary indication of legislative intention is the legislative text, read in context and having regard to its purpose. So statutes of law, also known as legislation, are the written laws of the United Kingdom. They are created and implemented by Parliament and enforced by various authorities, prosecuting bodies, etc. Interpreting the meaning of legislation is not always straightforward, and in some cases the judges are called upon to interpret the legislation in accordance with existing laws and rules of statutory interpretation. Statutory interpretation may be required where complexity and uncertainty arises as to how the law applies in a given situation. Those who draft legislation do their utmost within their extraordinary experience and drafting skills to craft legislation that is clear and unambiguous. However, sometimes the written law is not always clear. Typical problems include a failure within legislation to cover a specific point, ambiguity as to its meaning and drafting errors, new legal developments and changes to the use of language. When we look at why we need statutory interpretation, so as we said earlier, Parliament creates the law and judges apply it, but they must respect parliamentary sovereignty when performing this role. Once a judge makes a decision on how Parliament's law is to be applied, a precedent is created. When the laws of Parliament are clear, there's no issue as to how the law is to be applied. As we stated, it's only when the law becomes confusing or ambiguous that an issue of statutory interpretation is created. And sometimes it's things like, the broad terminology, or as we mentioned earlier, the ambiguity, it causes issues. So we're going to look at the rules of statutory interpretation and the importance of this, and why there's a need for these rules. These rules each take different approaches to interpretation of the words in legislation. Some judges prefer one rule, while other judges prefer another. Some judges also feel that their role is to fill the gaps and ambiguities in law, whilst others think that it should be left to Parliament as the supreme lawmaking body in the UK. As the rules can result in very different decisions, it's important to understand each of them and how they are used. So we're going to go through each one. First one, literal rule, the golden rule, the mischief rule, and the judge's discretion. So the first one, the literal rule. Under the literal rule, the words in a statute are given their ordinary and natural meaning. They will be read literally and do not need to be analysed further for different meanings, disregarding the plain words of the legislation. An example of a plain reading resulting in a harsh result is the Berryman case 1946, where a rail worker was killed while doing some oiling on a railway line as a result of there being no lookout point. The judge would not grant Mrs. Berryman compensation for her husband's death, as the relevant act only stated that lookout points had to be issued for workers relaying or repairing the line. Oiling did not come within either of the two categories. This result was clearly harsh and unjust, and to overcome such outcomes, the golden rule was introduced to modify the literal rule. As we mentioned earlier, the literal rule says that the intention of Parliament is best found in the ordinary and natural meaning of the words. As the legislative democratic part of state, Parliament must be taken to want effect exactly what it says in its law. If judges are permitted to give a non-obvious or non-literal meaning to the words of parliamentary law, then the will of Parliament, and thereby the will of the people, is being contradicted. In the case of Dupont Steels Limited and others against Sears and others 1980, Lord Diplock noted that where the meaning of a statutory words is plain and unambiguous, it is not then for the judges to invent fancied ambiguities as an excuse for failing to give effect to its plain meaning, because they consider the consequences for doing so would be inexpedient or even unjust or immoral. And another example of quite an important case in regards to the literal rule is the case of Fisher and Bell, 1960, and the restriction, in this case, the restriction of Offences Weapons Act 1959 made it an offence to offer for sale certain offensive weapons, including flick knives. James Bell, a Bristol shopkeeper, displayed a weapon of this type in his shop window in the arcade at Broadmead. The divisional court held that he could not be convicted because, giving the words in the statute a tight literal meaning, Mr. Bell had not offered the knives for sale. In the law of contract, placing something in a shop window is not technically an offer for sale. It is merely an ITT, which is an invitation to treat. It is the customer who makes an offer for to the shop when the offers money for an item on sale. The court upheld that under the literal meaning of the offer, the shopkeeper had not made an offer to sell and so was not guilty of the offence. And then the UK, you need to note that the UK Parliament subsequently changed the law to make it clear that displaying a flick knife after the Fisher and Bell case in a shop window was an offence. So now we're going to go on to the golden rule. So the golden rule is used to prevent inconsistency and absurdity when interpreting an act literally. It can be applied narrowly or widely. Under the narrow approach, the court can only choose between the possible meanings of a word. For example, if one meaning is apparent, then the meaning must be adopted. In the case of Alder and George 1964, the defendant was charged under the Official Secrets Act 1920 with obstruction in the vicinity of a prohibited area. Although the defendant had carried out the obstruction inside the area, the court did not restrict itself to the literal wording of the act and found him guilty. Under the wider approach, the courts can modify the words in order to avoid a problem, for instance, where there's an obvious and clear meaning, but this meaning would lead to an absurd result. For instance, in the case of Rees Sigsworth, 1935, the defendant had murdered his mother. Under the relevant Act of Parliament, the next of kin would inherit the deceased estate. Whilst this was clear, the literal rule would produce an unjust result. The golden rule was applied so that the next of kin would not inherit the estate where they had killed the deceased. The grammatical and ordinary sense of the words is to be adhered to unless that would lead to some absurdity as mentioned earlier, or inconsistency with the rest of the instrument, in which case the grammatical and ordinary sense of words may be modified so as to avoid the absurdity and inconsistency, but no farther. The golden rule provides no clear means to test the existence or extent of absurdity. It seems to depend on the result of each individual case. Whilst the golden rule has the advantage of avoiding absurdities, it therefore has the disadvantage that no test exists to determine what absurdity actually is. So the next rule is the mischief rule. Sometimes statutes can be defined more broadly by the courts to deal with unforeseen loopholes or ambiguities within the legislation, which may prevent Parliament's original intention being honoured. This application is known as the mischief rule and will be used where there is ambiguity. The mischief rule was laid down in the landmark case of Hayden's case in 1584, where the court said 4 issues need to be considered when interpreting statutes. These were, firstly, to examine the common law prior to the Act. Secondly, locate the mischief or defect in the common law. Thirdly, to identify the remedy Parliament meant to propose to eliminate the mischief. And fourthly, to give effect to that remedy. The mischief rule is narrower than the golden rule and only applied to determine the mischief and defect that statute was intended to remedy. The mischief rule requires the court to look at what the law was before the legislation was passed in order to discover what gap or mischief the legislation was intended to cover. The court is then required to interpret legislation in such a way to ensure the gap is covered, as we mentioned earlier in the Hayden's case 1584. The mischief rule also gives the court's justification for going behind the actual wording of the legislation in order to consider the problem that the particular legislation was aimed at remedying. At one level, it is clear that the most flexible rule of interpretation, but it is limiting to using previous common law to determine what mischief the legislation in question was designed to remedy. The example of the mischief rule came in the case of Cochlear and Carpenter 1951, which is an example of the use of the mischief rule. In 1950, Shane Cochlear was sentenced to 1 month's imprisonment for being drunk in charge of a bicycle in public. At about 2:45 p.m. on 18th of January 1950, the defendant was drunk and was pushing his pedal bicycle along Broad Street in Ilfracombe. He was subsequently charged under Section 12 of the Licensing Act 1872 with being drunk in charge of a carriage. The 1872 Act made no actual reference to bicycles. The court elected to use the mischief rule to decide the matter. The purpose of the Act was to prevent people from using any form of transport on a public highway whilst in a state of intoxication. The bicycle was clearly a form of transport, and therefore the user was correctly charged. The next rule to use is the judge's discretion. Judges have the discretion to apply any of these rules of statutory interpretation as they deem appropriate. Each of the rules has its imperfections, but it provides judges with the ability to interpret legislation in the best way possible to achieve the result as intended by Parliament when it was enacted. These rules of statutory interpretation provide a coherent and proven framework for the courts to follow to achieve the best possible outcomes of a case in accordance with legislation. In exercising their discretion, judges can use both intrinsic and extrinsic aids such as Hansard and other statutes, Law Commission reports and Royal Commission reports for the purposes of interpreting legislation. This reduces the risk of statutes being interpreted in a way that contradicts other legislation. So 2.2, now we're going to be looking at identifying the intrinsic and extrinsic aids in regards to statutory interpretation. So aids to interpretation. Firstly, as well as the four main approaches to statutory interpretation, a judge has other aids available to him to help him determine the meaning of statute. These can be divided into internal, which are intrinsic aids, and external aids, which are extrinsic aids. So extrinsic aids are matters which may help put an act into context. These are found outside of the actual statute, which may be considered by judges to help them understand the meaning of a statute more clearly. The following intrinsic aids have been regarded as acceptable. The long and the short title, the preamble normally states the aim of the act and intended scope, the definition section, the headings, the schedules. These are intrinsic aids. So the advantages of intrinsic aids. It is more respectful of Parliament to look elsewhere in the Act rather than outside the Act. It is quick and easy to look at things like marginal notes, which are helpful in Tivnan, or at long title used in the case of Cornwall, CC and Baker. Some internal aids like interpretation sections and schedules are designed to provide definitions and explanations, so it's common sense to look at them. For example, Section 10 of the Theft Act explains the meaning of a weapon of offence. Intrinsic aids disadvantages. Problems with wording are not likely to be solved by looking elsewhere in the Act, especially if the words are ambiguous as in Allen, or very plain but wrong as in Whiteley and Chappell, 1868. Internal aids are alone are unlikely to be sufficient, and if judges were not allowed to refer to anything outside the Act, it would be more difficult for them to avoid avoid unfair or absurd decisions. Intrinsic aids are matters within an act itself which may help make the meaning clear, as mentioned earlier. Other useful internal aids may be headings, as mentioned earlier. These are, for example, another example for internal aids is the 1963 Animal Boarding Act, Section 5, subsection 2, which states, in this act, animal means any dog or cat. The Interpretation Act 1978, Section 6 also states that unless the contrary intention appears, words importing the masculine gender also include the feminine, and words importing the feminine gender also include the masculine. So in addition, words in the singular also include the plural, and words in the plural include the singular. Now we're going to look at our extrinsic aids, and these are matters which may also help put an act into context. Intrinsic aids are materials found outside of the act in question, which may be used by the court in order to aid interpretation. Explanatory notes are published outside the act and have been used since 1998. In the case of R and National Asylum Support Service, Lord Stein noted that they can cast light on the objective setting or contextual scene of the statute and the mischief at which it is aimed. There are things found outside of the actual statute which may be considered by judges to help them understand the meaning of a statute more clearly. Intrinsic aids are things like that are acceptable are dictionaries and legal textbooks, other statutes, reports of the Law Commission and other law reform bodies, internal treaties, and explanatory notes. Intrinsic aid sources, so dictionaries and legal textbooks. So dictionaries are an obvious tool to assist with the literal rule. Other statutes, earlier acts, have relevance in tracing the mischief that an act was designed to tackle. Reports of the Law Commission and other law reform bodies. So an act is often preceded by an investigation by one of the bodies set up by the government to investigate options for reforming the law. These bodies produce reports on their findings and recommendations which the government may adopt in a bill. International treaties, it is presumed by the courts that Parliament does not legislate in a way that would be clear breach of a treaty signed by the United Kingdom's government. And then explanatory notes, which are acts passed since 1999, which have been accompanied by explanatory notes. These notes summarize the main provisions of the Act and explain the background to it. The government department responsible for the legislation writes them after the Act has been passed. For this reason, they should be regarded as intrinsic aids. Intrinsic aids also can include international conventions, regulations or directives which have been implemented by English legislation. It is thought that English law should be interpreted in such a way as to be consistent with international law. Section 3 of the Human Rights Act 1998 expressly states that as far as possible it is possible to do so, an act must be read and given effect in a way which is compatible with the rights of the European Convention on Human Rights. This only applies to any case where there is an issue of human rights. Intrinsic aid advantages. Using a dictionary is a quick and easy, as in the Cheeseman and Vaughan case. Using Hansard might clarify what Parliament meant, as in Davies and Johnson. Lord Denning said that not to use it would be like groping around in the dark without putting the light on. Europe allows background papers to be used, so it is sensible for English courts to use them when acts are based on international laws, as in the case of Fothergill and Monarch Airlines. Intrinsic aid disadvantages. Using Hansard may not reveal what Parliament as a whole intended, as in the case of Pepper and Hart, which restricts the courts to consider what ministers said, actually said, but Parliament may have decided not to follow the minister's view. What the minister said may not be clear, as in the case of Deegan. Court ruled that Hansard couldn't be used because what the minister said was not clear. Lord Bingham said if the statement is unclear, the courts would be tempted to compare one statement with another and run the risk of questioning proceedings in Parliament, which constitutionally they are not allowed to do so. Danger of treating materials are not part of the Act as having the same status as the Act and therefore undermining the authority of Parliament. This is the main objection to use external aids, particularly for those other than dictionaries, which are less objectionable. Now, what I'm going to do now is put a video on internal aids in regards to statutory interpretation, which are intrinsic aids. So this video that I've got on now is looking at aids to statutory interpretation, but is looking at internal aids. with reference to examples.
Aids to statutory interpretation, internal aids. Internal aids to statutory interpretation, also known as intrinsic aids, are those contained inside the statute or published alongside it. These include 1. The long title of the Act. 2. The words of the statute. 3. Definition sections. 4. Explanatory notes. And 5. Codes of guidance. 1. The long title of the Act. The long title of the Act may give an indication of the aims or purpose of the legislation and thereby assist judges where there is ambiguity in the wording of the contents of the statute. For example, the Abortion Act 1967 has the long title, An Act to Amend and Clarify the Law Relating to Termination of Pregnancy by Registered Medical Practitioners. This was used in RCN versus DHSS to allow nurses to terminate pregnancy by administering hormones. 2. The words of the statute. Judges may look at other sections in the Act to help decide the meaning of the section under consideration. For example, in Cundy v. Lecoq, the defendant was charged with selling alcohol to an intoxicated person under Section 13 of the Licensing Act 1872. The defendant did not know the customer was drunk. Section 13 did not state that knowledge of the drunkenness was required. The court noted that other offences under the Licensing Act did mention that knowledge was required. They concluded that the omission to refer to it in Section 13 was deliberate. The defendant was liable. 3. Definition sections. Most statutes will contain definition sections stating a particular meaning of words for the purposes of the Act. For example, Section 3 of the Theft Act 1968 defines an appropriation as any assumption of the owner's rights, whereas Section 4 indicates what constitutes property for the purposes of the Theft Act. 4. Explanatory notes. All public bills are now published with explanatory notes. These were introduced in 1999 and provide some explanation of the purpose of the legislation. 5. Codes of guidance. Some statutes, particularly those that have to be followed by public agents, will have accompanying codes of guidance explaining how the legislation should be implemented. For example, the Police and Criminal Evidence Act 1984, PACE, has codes A to H which set out guidance on how the police can exercise their powers in stop and search, arrest, detention and interviewing of suspects. Other examples include the Code of Practice for the Equality Act 2010. Also, the Homelessness Code of Guidance, for local authorities for use when applying the Homelessness Reduction Act 2017. Whilst such codes are taken into account by the courts, they are not binding. In summary, internal or intrinsic aids to statutory interpretation include the long title of the Act, words of the statute, definition sections, explanatory notes and codes of guidance. This video is part of a series of videos on law from www.e-lawresource.
As we can see, the importance of internal aids in regard to the statute itself and why there's a need for long titles, short titles and preambles, and why there's a need for internal and extrinsic aids. So the exercise for the next session is look at the following cases. So look at Alder and George 1964, we had a brief look at it. Hansard Statute, Cornwall, CC and Baker, Whiteley and Chapman 1868, Cheeseman and Vaughan, Davies and Johnson, what Lord Denning said, and also look at Fothergill and Monarch Airlines and Pepper and Hart. Also a mind map for the exercise. So we looked at intrinsic and intrinsic aids. So we looked at intrinsic aids being long, short title of the Act, which is the Abortion Act. So long title examined for the words registered medical practitioner. Preamble, which is the preamble, which is the sets out the purpose of the Act. definitions section explains the meaning of the specific words, schedules, additions to the main body of the Act, and punctuation can change the meaning of the particular words. And then we've got extrinsic aids, which are dictionaries, uses to find the literal meaning of words, Hansard, debate notes from Parliament, reports, previous versions of the Act, Interpretation Act, international treaties, textbooks, and explanatory notes. So this mind map actually identifies to you why there's a need for extrinsic and intrinsic aids. So overall, to look at statutory interpretation, why it's so important, statutory interpretation is important to access to justice because it helps the judiciary system implement the law in an efficiency and effective way and helps Parliament make the law. Statutory interpretation may be required where complexity and uncertainty arises as to how the law applies in a given situation. Those who draft legislation to do their utmost within their extraordinary experience and drafting skills to craft legislation that is clear and unambiguous. In regards to using the statutory approach in the UK, in the modern approach, it recognises that language of the statute is just one factor to be considered, and the other factors such as the purpose of legislation, the context in which the statute was enacted, and the social and political values of community should also be taken into account. And this is the end of the session on Learning Outcome 2, and these are the references that you could refer to in regards to trying to do the exercises and look at the mind maps in regards to intrinsic and intrinsic aids. So these are all the references that you could refer to. If there's any other references, they will be on Moodle on the unit 3.27, the English legal system, and there'll be additional reading for you there, journals and additional cases for you to have a look at. Thank you for attending today's session, and the next learning outcome is Learning Outcome 3.